All right, welcome back to the Daily Facts, and we are now into part 7 of the Sidney Powell lawsuit against Georgia for election voter fraud. All right, so let's get right into it. Applying pro rata the above calculations separately to Cobb County based on the number of unreturned ballots, a range of 1,255 and 1,687 ballots ordered by third parties, and a range of 2,338 and 2,897 lost mail ballots, plus 10,684 voters documented in the NCOA as having moved for a combined minimum of 14,276 missing and unlawful ballots and maximum of 15,250 missing and unlawful ballots, which exceeds the statewide presidential race total margin by a range of as few as 1,606 ballots and as many as 2,580 in the county of Cobb alone, impacting the Cobb County Republican Party. Cobb County Republicans, see Exhibit 1. Mr. Brainerd also found a pattern in Georgia of voters registered at totally fraudulent residence addresses, including shopping centers, mail drop stores, and non residential facilities. In some, with the expert analysis of William M. Briggs, PhD, based on extensive investigation, recorded calls, and declarations collected by Matt Brainerd, see attachments to Exhibit 1, Briggs Report. The extent of missing and unlawfully requested ballots creates substantial evidence that the mail ballot system has fundamentally failed to provide a fair voting mechanism. In short, tens of thousands of votes did not count, while the pattern of fraud and mathematical anomalies that are impossible absent malign human agency makes clear that tens of thousands were improperly counted. This margin of victory in the election for Mr. Biden was only 12,670 and cannot withstand most of these criticisms individually and certainly not in aggregate. Cobb County, based on lost votes, unlawfully requested votes, and NCOA data on these facts alone, would consume more than the entire margin of the statewide difference in the presidential race. Russell Ramsland confirms that data breaches in the Dominion software permitted rogue actors to penetrate and manipulate the software during the recent general election. He further concludes that at least 96,600 mail-in ballots were illegally counted, as they were not cast by legal voters. In sum, as set forth above, for a host of independent reasons, the Georgia certified election results concluding that Joe Biden received 12,670 more votes than President Donald Trump must be set aside. Count 1. Defendants violated the Elections Clause and 42 U.S.C. 1983. Plaintiffs allege all preceding paragraphs as if fully set forth herein. The Electors Clause states that each state shall appoint in such manner as the legislature thereof may direct a number of electors for president. Article 2, 1, Clause 2. Emphasis added. Likewise, the Elections Clause of the U.S. Constitution states that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Article 1, 4, Clause 1, emphasis added. The legislature is the representative body which makes the laws of the people. Smiley, 285 U.S. at 193. Regulations of congressional and presidential elections, thus, must be in accordance with the method which the state has prescribed for legislative enactments. ID at 367. See also Arizona State Legislator versus Arizona Independent Redistricting, 135 S. Court 2652, 2668, 2015. Defendants are not part of the General Assembly and cannot exercise legislative power. Rather, defendants' power is limited to taking care that the laws be faithfully executed. Pennsylvania Constitution, Article 4(2). Because the United States Constitution reserves for the General Assembly the power to set the time, place, and manner of holding elections for the President and Congress, county boards of elections and state executive officers have no authority to unilaterally exercise that power, much less to hold them in ways that conflict with existing legislation. Defendants are not the legislature, and their unilateral decision to create a cure procedure violates the Electors and Elections Clause of the United States Constitution. The Secretary of State and the State Election Board are not the legislature, and their decision to permit early processing of absentee ballots in direct violation of the unambiguous requirements of OCGA 21-2 386A 2 violates the Electors and Elections Clauses of the United States Constitution. Many affiants testified to many legal infractions in the voting process, including specifically switching absentee ballots or mail-in ballots for Trump to Biden. Even a Democrat testified in his sworn affidavit that before he was forced to move back to where he could not see, he had in fact seen. I also saw absentee ballots for Trump inserted into Biden's stack and counted as Biden votes. This occurred a few times. See Exhibit 18, paragraph 12. Plaintiff's expert also finds that voters received tens of thousands of ballots that they never requested. See Exhibit 1, Dr. Briggs' report. Specifically, Dr. Briggs found that in the state of Georgia, based on a statistically significant sample, the expected amount of persons that received an absentee ballot that they did not request one ranges from 16,938 to 22,771. This range exceeds the margin of loss of President Trump by 12,670 votes, by at least 4,268 unlawful requests, and by as many as 10,101 unlawful requests. This widespread pattern, as reflected within the population of unreturned ballots analyzed by Dr. Briggs, reveals the unavoidable reality that, in addition to the calculations herein, third parties voted an untold number of unlawfully acquired absentee or mail-in ballots, which would not be in the database of unreturned ballots analyzed here. GCA 21-2-522. These unlawfully voted ballots prohibited properly registered persons from voting and reveal a pattern of widespread fraud. Further, as shown by data collected by Matt Brainerd, there exists clear evidence of 20,311 absentee or early voters in Georgia that voted while registered as having moved out of state. Specifically, these persons were showing on the National Change of Address Database, NCOA, as having moved or as having filed subsequent voter registration in another state, also as evidence that they moved and even potentially voted in another state. The 20,311 votes by persons documented as having moved exceeds the margin by which Donald Trump lost the election by 7,641 votes. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the injunctive relief requested herein is granted. Defendants have acted and, unless enjoined, will act under color of state law to violate the elections clauses of the Constitution. Accordingly, the results for President and Congress in the November 3rd, 2020 election must be set aside. The results are infected with constitutional violations. Count 2. The Secretary of State and Georgia counties violated the 14th Amendment U.S. Constitution Amend, that's 1442 U.S.C. 1983, denial of equal protection, invalid enactment of regulations affecting observation and monitoring of the election. Plaintiffs refer to and incorporate by reference each of the prior paragraphs of this complaint as though the same were repeated at length herein. The 14th Amendment of the United States Constitution provides, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. See also Bush v. Gore, 531 U.S. 98, 104, 2000. Having once granted the right to vote on equal terms, the state may not, by later arbitrary and desperate treatment, value one person's vote over the value of another's. Harper versus Virginia Board of Elections, 383 U.S. 663 665, 1966. Once the franchise is granted to the electorate, lines may not be drawn which are inconsistent with the Equal Protection Clause of the 14th Amendment. Okay, we're going to end there and we'll pick up on the next part coming very soon. Thank you for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment, and we'll talk again soon. Bye.